Miranda in DUI cases is sort of a tricky situation because you really have two bodies of law that you're dealing with. With the criminal justice system and the criminal charge of DUI, Miranda absolutely applies. One has all the constitutional rights that Miranda encompasses, such as the right to an attorney, the right to remain silent. All of those rights apply in the criminal case, so that therefore when one is arrested or placed in custody as a result of a DUI arrest, that person should be advised of their Miranda rights, and if they're not and they continue to talk or they're interrogated, those interrogations could have consequences. It's possible that we could get certain evidence such as, where the person was drinking, how much they had to drink. If those questions are asked without being advised of the person's Miranda rights, it is possible that we could get that type of information suppressed. It's not a per se situation where the charge would be dismissed if someone has not read their Miranda rights. However, we also deal with the Department of Motor Vehicles concerning the person's driver's license. And in that hearing, in those proceedings, Miranda does not apply because it's under administrative law, not under criminal law. So it's sort of a tricky situation in that Miranda applies in one part of the case, but not necessarily the other. What we typically see with DUI is we typically see the person arrested out on the road, possibly advised of their rights verbally before they're placed in the backseat of the police officer's car and then transported to the police department. Once they're at the police department, generally the person will be advised of their rights in writing and will be asked to sign a notice of rights form. And generally once the person does that, if they elect to talk or give any information about their case thereafter, they're deemed to have waived their Miranda rights at that point.